Ani, Bazoo, Nagani, Anishnabeki, Nini, Stacey, Laforme, Disnakas, Credit Dunziba, Mainga Dogam, Mississauga, Anishinaabe Dao. I'd like to acknowledge the Creator, the world around us, and our place within it. I'd like to acknowledge the many nations that walk this land in the past, the many nations that walk it today, and welcome you to the treaty lands of the Mississaugas of the Anishinaabe. Now, I've never been a moderator before, so, I'm going to make a lot of mistakes, so everybody forgive me. I might talk too much, but that's all right. Just tell me shh. And I'd like to offer you a prayer that I wrote during the time of the COVID. We acknowledge the Creator, the world around us, and our place within it. We thank you for the gifts we have been given, the gifts of this world, the insects, the animals, the plants, the people. We are thankful for the breath of life, the gift of spirit and energy. We ask that you shelter us and guide us in these difficult and challenging times. We ask that you protect our elders, our knowledge keepers, for they are the keepers of our wisdom, our language, and our past. We ask that you protect and guide our youth, for they seek direction. They were born to run, and it is a time of stillness. They are our hope, our future. We ask that you protect the women of the world, for they are the bringers of life and the foundation upon which we build our future. We ask that you guide and protect our warriors, for they too seek direction. They serve the will of the people and struggle without that voice, that guidance. We ask that you calm and comfort our leaders. We need their logic and their compassion, yet they are overcome with the pain and hurt of the people. We ask that you shelter and guide the other people of these lands. They are our brothers and sisters, though at times they fail to see us. Without them, we cannot achieve the purpose for what we were set upon this world. We understand that we must stand together, that we must face this dark time in unity. We understand that there's a lesson here for all people, and we pray that they and we understand it. We acknowledge the Creator, the world around us, and our place within it. Miigwech. Thank you. So today we're here to have a good time, impart some wisdom. I'll rely on the speakers for that. We're going to talk about cities and Indigenous relationships. We're going to explore the legal relationship between First Nations, municipalities, and the responsibilities of city governments towards Indigenous people that live within the colonial boundaries of municipalities. Now you can tell I didn't write that because it had too many long words in it. So our panelists, in no particular order: Joanne Heritz, Alexandra Flynn. Our two commentators are Jean Leclair and Kia Dunn. So I'm going to start off by asking Joanne Heritz, the Assistant Professor, Department of Political Science from Brock University, to start us off.
Okay, thank you. Thank you so much, Kima Laforme. Thank you for your introduction, and also to thank the Constitutional Space for Cities for the opportunity to share my my research with you. So I'm going to. And can you see my screen? Okay, so I'm hoping that you can see my screen. Okay, so I am coming here. I'm presenting from St. Catharines, Ontario, home of Brock University. And Brock University acknowledges the land on which we gather is a traditional territory of the Haudenosaunee and Anishinaabe peoples, many of whom continue to live and work here today. This territory is covered by the Upper Canada Treaties and is within the land protected by the Dish with One Spoon Wampum Agreement. Today, this gathering place is home to many First Nations, Métis, and Inuit peoples, and acknowledging reminds us that our great standard of living is directly related to the resources and friendship of Indigenous peoples. So I will be talking about the obligation of cities towards Indigenous peoples. Okay. So at its most basic level, urban Indigenous peoples consist of all First Nations, Métis, and Inuit who live in cities. While some of them may be First Nations and have status while they are on reserve, with very few exceptions, this status does not get recognized when they are off reserve. Most of Canada's Indigenous peoples live in cities. There are no governance systems by the federal government or by any one of the provinces for Indigenous peoples in cities across Canada. So what has happened over time is the federal government has devolved some of its responsibilities for Indigenous peoples to the provinces, and the provinces in return contested some of these decisions. So this leads me to my research question. What are the obligations of cities towards Indigenous peoples? So first we need to look at the Constitution Act of 1867. The Crown aspect of the relationship between Indigenous peoples and the government actually split with the Constitution Act, and it gave the federal government jurisdiction over Indians and lands reserved for Indians, as stated in the Act. The fact that provincial constitutional responsibilities did not include Indians, as the wording was at the time, but did include municipal responsibilities, would have future implications for federal and provincial jurisdictional disputes regarding Indigenous peoples as they increasingly transition to cities starting in the mid-20th century. So next, the Act to amend and consolidate the laws respecting Indians, or the Indian Act of 1876, ignored the traditional governing structures that Indigenous peoples had in place. The aspects of the Act that would eventually impact on urbanization was state control over their status. And there's a lot of impacts that the Indian Act had on Indigenous peoples. So for Indigenous peoples, for the most part, were not considered citizens in the Act, and the Act also provided means by which they would retain their status or they would lose it and become citizens. So together, the Constitution Act of 1867 and the Indian Act of 1876 established the status of and responsibilities for Indigenous peoples. Although the Constitution Act delegated responsibilities for Indigenous peoples to the federal government, over time, the federal government actually relinquished that responsibility. First to the Métis, second to non-status Indians, third to Indigenous peoples residing off reserve, and fourth to the Inuit. So the federal government allocated primary service delivery responsibilities to the provinces through an amendment to the Indian Act in 1951. And in doing so, the federal government acknowledged that its obligations for Indigenous peoples were limited to reserves. And there are a few exceptions for this, but for the most part, federal responsibilities did not extend to Indigenous peoples living in cities. But one important thing to remember is that urban centers are not places that Indigenous peoples travel to, because we know that they are always in their traditional territories when they are wherever they are, including urban centers. So assisting Indigenous peoples as they increasingly migrated to cities, friendship centers were established about 60 years ago. And in 1972, the National Association of Friendship Centers was established to link friendship centers across Canada and to advocate for urban Indigenous peoples. Urban Indigenous peoples are really not represented by one specific political organization, although the Congress of Aboriginal Peoples, CAP, comes closest to representing off-reserve status and non-status Indians, Métis, and the Southern Inuit. But there's no one organizing body, so we really have to look at various sources to piece together the urban Indigenous experience. So one place I'm going to start with is the Royal Commission on Aboriginal Peoples. So the Royal Commission, or but also known as RCAP, when it looked at urban people living in cities, it identified 4 critical issues. So the first is the extent to which urban Aboriginal peoples can maintain a positive cultural identity based on spirituality, language, elders, values, and traditions, family, and ceremonial life. Second is the exclusion from opportunities for self-determination. So within this critical issue, RCAP proposed two models for the inclusion of Indigenous peoples in local government. And one was a co-management governing system that would involve various levels of government providing services. The second was a community of interest model where Indigenous organizations would develop a citywide form of self-government. The third critical issue was discrimination that Indigenous peoples face when they are in cities. And the fourth was the challenges that Indigenous peoples face in finding culturally appropriate services in cities. So the commission represented that in addition to having culturally appropriate services, that Indigenous peoples should be involved in their design. A lot of the recommendations from RCAP were not acted upon, including the two models of self-determination. So coming out of RCAP was the Urban Aboriginal Strategy. The UAS was designed to use a collaborative approach to link organizations at all levels of government, municipal, provincial, and federal, that were providing Indigenous programs and services, and to focus on priority areas of improving life skills, promoting job training, promoting job training and supporting Indigenous women, children, and families. It started in 1998 with a 4-year, $50 million program. So it initially operated in 13 cities whose combined Indigenous identity population represents more than 25% of Canada's total Indigenous population. In 2014, the federal government actually consolidated funding, and it actually combined funding for friendship centers and for its urban Indigenous programming into a single UAS with a focus to increase economic participation for urban Indigenous peoples. In 2017, it reevaluated that and realized that the economic participation piece was not working well. So it actually created a new program, Urban Programming for Indigenous Peoples, with a budget of $53 million annually, and provided programs and services for women, vulnerable populations, including youth, transition services, outreach program, and community wellness. So at the local level, the UAS was described as filling in gaps in services. So what it wanted to do is that the federal government really wasn't involved very much in programs and services for Indigenous peoples, but it wanted to bring together all these various organizations as a way to determine gaps in services, and to bring people together as a way to collaborate on programs and services for Indigenous peoples. The criticisms for the UAS focused on a competitive funding environment. All these organizations were competing for the same dollars, for the same funding. And also the criticism also focused on the comparatively small amount of funding for over half of Canada's Indigenous peoples. And there are more criticisms, but I can discuss that later if we have time. So the Urban Aboriginal Peoples Study is also instrumental in confirming the aspirations of urban Indigenous peoples. And one thing I found from looking at it is that it continues to support the critical issues that were reported in RCAP. So selected findings indicate that Indigenous peoples are more positive about their identity than at any other time in the past. That a majority indicate that they or a family member attended a residential school, and that the residential school experience has had an impact on their lives today. They strongly support alternative justice approaches because they believe that it would reduce Indigenous crime rates. Likewise, they support traditional healing practices because they feel it's more important than access to mainstream healthcare. Negative experiences that Indigenous people that they experience with non-Indigenous services, such as schools or child welfare systems, includes racism and discrimination and a lack of empathy. So these findings align with the critical issues from RCAP, indicating that the residential school experience impacts on Indigenous peoples today, the discrimination they face, and their preference for culturally appropriate alternative justice and traditional healing. Okay, so more recently, the Daniels decision put an end to the wrangling between the federal government and the provinces, and its decision that affirmed federal responsibility for non-status Indigenous peoples and Métis under Section 9124 of the Constitution Act. So it really focuses on the federal government as the level of government that has responsibility. So this really wraps up what I was looking at with the federal responsibilities for Indigenous peoples. So when we're looking at what responsibilities municipalities have, we realize that we're really asking, about the responsibilities or obligations of cities. And it really means that in this context, that municipalities are really on their own when it comes to providing or bridging relations with Indigenous peoples. One source of guideline is the Truth and Reconciliation Commission. Of its 94 calls to action, 5 of them specifically include municipalities in their calls to action. And the one that I just wanted to use as an example is call to action 57, which specifically asks municipalities to have staff training in intercultural competency. So over time, municipalities have been bridging relations with Indigenous peoples. But what I'm trying to figure out is, what that relationship looks like and how Indigenous peoples are included in urban governance. So what I've done, just for the sake of time, is I've chosen to discuss the selected findings from 3 studies I've conducted. So the first one is looking at large cities, some largest cities in Canada: Vancouver, Edmonton, Winnipeg, and Toronto. And we see that they have Indigenous advisory committees within their municipalities. That the one in Toronto is over 20 years old, but within the other municipalities, they're fairly more recent. That we have Indigenous liaison staff within these municipalities. And we also see that there's varying degrees of Indigenous identity population. So it seems as though Indigenous identity populations isn't really a factor. It seems to be the fact that these are larger urban centers and that have created these Indigenous advisory committees. Next, I looked at Saskatchewan with a significant Indigenous identity population, and noticed that, as we can see, at 10 and 12%, Regina and Saskatoon respectively have a they have significant Indigenous identity populations, that they have one member of municipal staff as Indigenous liaison, but that there aren't any advisory committees, that they're refer to them as informal networks. We see that Prince Albert, with over almost half of its population as Indigenous, really has nothing in place as far as advisory committees, as far as any type of liaison with the Indigenous community. So the third study I did was in Ontario, and I looked at the area closest to the 6 nations of the Grand River. And Brantford, as an example, has a significant Indigenous identity population. Its relations are really with the 6 nations of the Grand River, with the First Nations itself, rather than with anyone within the municipality who identifies as Indigenous. So it sort of has the same pattern similar to Prince Albert. When I look at St. Catharines, I should say, when I look at Niagara, it's a larger regional municipality with 12, it's 2-tier with 12 lower tier municipalities. But we see that Niagara itself hasn't really been bridging too many relationships with Indigenous peoples other than its social services. So, and we see that St. Catharines actually has a memorandum of understanding with the Niagara Regional Native Center. But Hamilton, within the third municipality that was looked at in this study, has an Aboriginal Advisory Committee that's been in place for almost 20 years. It has an urban Indigenous strategy that has been in place for 6 years. It has 2 liaison staff, even though it has a smaller urban, I should say an Indigenous identity population. So we can see that when we're looking at this, and also another thing about Hamilton is that it has, its urban Indigenous strategy plans to align with 17 of the calls for action by the TRC. So the federal government has responsibility for Indigenous peoples in urban centers. But one thing that's revealed is that we know that from input from people in urban centers, that it is important for them that they, respecting they're very positive about their identity, that they're very much, that their residential school experience is still part of their, it's part of their, it's part of them, and the discrimination they face and their desire for autonomy in programs and services. So over the last 10 years or so, municipalities are taking it upon themselves to bridge relations with Indigenous peoples, and we see a variety of approaches. However, we've noticed that larger centers, regardless of the percentage of identity of urban Indigenous identity population, they're the ones that are really building relations with urban Indigenous peoples in Canada. I'm going to end it there, and thank you for your time, and I look forward to continuing the discussion. Now I'm going to stop sharing.
Okay, thank you very much.
Okay, and okay, thank you.
Hopefully you can hear me okay. I'm very bad with this technology, so if I cut out or something goes awry, just wave your hands. Miigwech to Gima Laforme for serving as moderator for this panel, and many thanks to my fellow panelists and commentators, and especially to those of you in the audience. I had a look at the names of the folks, and it feels a bit like a gathering of friends, old friends, but also new friends. And I'm really grateful that you, of all the things you could be joining in your busy days, that you're here with us on Zoom to listen to this panel. The picture that's in front of you, if the slide is up, which hopefully it is a photo of Sanok, which is on the traditional, ancestral, and unceded territories of the Squamish Nation within a municipal center that Canadian law calls Vancouver, which is the lands of the Musqueam, Squamish, and Tsleil-Waututh Coast Salish peoples. It happens to be a couple of kilometers from where I live. And yesterday, when I was thinking about this presentation, I went for a run and I took a picture of Sanok's sign, of the Squamish Nation sign showing Sanok. But if you haven't had a chance to do so, I really recommend that you go and look at the plans that the Squamish Nation has for this area. And it actually kind of crystallizes, I think, the message that I hope to make today, which is that Indigenous municipal legal relationships start with the presumption that First Nations are their nations. They have their own laws. There's a multiplicity of laws that exist, and that part of our role in thinking about the constitutional status of cities is to understand that we are on First Nations land, and that we are operating alongside Indigenous laws. So like many of us, here in this Zoom room, I have deep roots in the settler nation. My grandparents came from other countries to Saskatchewan, and claimed Treaty 6 lands as their own for farming and for serving as grain elevator workers. And, you know, by pure, I think, luck and serendipity, as a child, I ended up with a mom who helped me to be aware of Indigenous laws and lands by living in Indigenous communities. So I spent a good part of my childhood in places like Churchill, Manitoba, and then Qaluit in Nunavut. And it has entirely framed the way that I look at municipalities and what role and responsibilities municipalities should have with respect to Indigenous communities. So in this presentation, what I'm going to argue is that whenever we think about reimagining the constitutional power of municipalities, we must understand the implications for First Nations and Indigenous peoples, and not merely by the Canadian laws set out in the Constitution, in their Constitution, in our Constitution, or in various municipal bylaws or what have you, but at a much deeper and core level that we are on Indigenous territory. So this is just a map that's taken from the website nativeland.ca, which again, if you're looking for something to do while you're listening to me talk, please go on this website and look, just enter the name of where you happen to be. And you'll see the many nations that overlap on the territories where you are located right now. We're all located on Indigenous lands, and this is a good reminder of making us aware of the names of the places that we're on. And it's also a reminder that Indigenous lands overlap municipal boundaries. And by Indigenous lands, what I mean are the many kinds of interests that First Nations have in regards to land and resources. So this can include reserves that are so defined under the colonial instrument of the Indian Act, but they also include treaty lands, traditional territories, and all of these have their own legal frameworks. And in addition, many, within, just to go back to what I said in the very first slide, what we think of as cities can have multiple Indigenous lands and Indigenous laws that apply to them. And so it's not just, Indigenous lands do not cleanly overlap alongside municipal boundaries. In fact, it's quite the reverse. Municipal boundaries were created without regard to where Indigenous spaces are. And in addition, there are many Indigenous peoples that reside within cities that may not be members or belong to the First Nations or bands under the Indian Act that lie within or alongside those lines. So, you know, it's a reminder, I think, to all of us that unfortunately, the legal and governance relationships that exist amongst Indigenous peoples and cities remains largely unexplored in the Canadian context, notwithstanding the fact, like the picture that you see up here, there is this overlap of land and laws, and there are many Indigenous peoples who reside within urban centers. So what I'm going to do today is I'm just going to briefly talk about Canada's colonial history and just acknowledge for all of us in the room that it includes municipalities, that municipalities are colonial creations. Second of all, I'm going to talk about how the Constitution specifically impacts Indigenous municipal legal relationships within the context of the duty to consult and accommodate. And then I'm going to talk about some next steps that we might want to think about in our discussion. Guima Laforme mentioned at the beginning that this is supposed to be fun, but it's of course it's a really important and heavy topic because there has been such violence towards Indigenous people that has happened by cities and continues to happen within cities. But at the same time, it's such a good thing to be able to talk about it and talk about it with the community of people who are here today. So this is a picture from Hansard, which has a quote. It's probably a little bit hard for you to read, but I've pulled up the important piece of it. This was in the last year of Prime Minister Sir Wilfrid Laurier's tenure, where the Indian Act was reformed to basically allow for the removal of Indigenous peoples from cities. And the reason why this is so poignant is, actually today is the anniversary of the city of Vancouver's creation. But, Canadian cities are located on Indigenous nations, and they were Indigenous nations for time immemorial, but were valuable to European nations that came to these lands. They were economically beneficial to colonizers, and so therefore they were claimed as spaces where cities should be created. So there were many ways in which European settlers and Canadians have violated the rights and interests of Indigenous peoples over time. I hope we've learned about many of them with the Truth and Reconciliation Commission in regard to residential schools. But the displacement of Indigenous peoples from urban centers is very much at the core of why cities are where they are. And part of the challenge in the discussion that we're having today is that the federal government claimed jurisdiction over Indigenous peoples and lands, notwithstanding where there were treaties in Canada, the treaties spelling out values like the two-row wampum and other mechanisms to live harmoniously. Those treaty rights were violated. But the Indian Act in particular has created a settler property regime with practices that continue to affirm the economic interests of cities. And so this is part of the discussion that we have to acknowledge in our opportunity to have a conversation about these issues today. So there are three main ways that Indigenous peoples and municipalities come together, or why this discussion is so poignant when we talk about constitutional issues at a conference such as this. So first of all, there are treaty relationships and Indigenous claims within and adjacent to cities, as I mentioned before. And so a treaty may recognize Indigenous rights to hunt or fish or trap. They may be constitutionally protected, and they often overlap with municipal lands, which means that local governments must be aware and must adhere to the treaty rights that apply. Second of all, First Nations may have reserve lands pursuant to the Indian Act that are within or adjacent to municipalities. So Sanok, the picture that I have up, is reserve land. This will be an urban reserve that is governed by Squamish Nation laws. It is entirely within the jurisdiction of the Squamish Nation. And there are some, I'm not going to be able to have time to talk about it today, but there's some really complex and important practices that take place around urban reserves and the power that municipalities have with respect to services, especially that relate to those lands. So that's a second way that that municipalities impact the rights of Indigenous peoples and their lands. And the third, which Joanne spoke about earlier, has to do with the fact that cities are home to Indigenous people. So many, over half of the population of Indigenous peoples reside within cities. And as a result, there are a number of service agreements, housing realities and interests that Indigenous peoples have within cities, including the need for representation and governance. So that's just a very quick background to kind of the colonial context in which we're operating. It's not really enough time to go into any detail, but I'm very happy to not just answer questions, but I'm sure I know many of you who are listening have a lot of expertise as well. So if you'd like to share information about that too, that would be really helpful. What I mainly want to focus on is the way in which the Constitution impacts Indigenous municipal relationships. So this is, I'm drawing inspiration from a scholar and friend, Mariana Valverde, in showing the overlap of laws. And so within the urban sphere, we have federal, provincial, municipal laws all operating alongside one another. So I think most of us nerds at the table who are interested in constitutions and cities would understand that overlap on a daily basis, especially I think I saw some counselors or former counselors on the list. You know how much you have to navigate this overlap of laws on a daily basis. But in addition, as I mentioned before, we have Indigenous laws that operate within urban centers as well. And we also have international laws, and in particular, the UN Declaration of the Rights of Indigenous People. So all of these laws are operating alongside one another. We tend to focus most of all, at least in this forum, on the Constitution itself. And there are a couple of parts of the Constitution that really matter in this discussion. So one is the overlap of section 91 and 92 of the Constitution, which are what powers the federal and provincial governments have. So in the earlier panels today, you would have heard some talk about that. What stuff is in the bucket of the federal government and what powers are within the bucket of the provincial government? Because in the provincial bucket are municipalities. We fall within that section 92. And in the federal bucket, the interests of First Nations are claimed to be part of federal responsibility. So that's one part of the Constitution that's really meaningful. But another equally, if not more important aspect of the Constitution that's meaningful is section 35, which I have up in front of you today. And this sets out that existing Aboriginal and treaty rights of Aboriginal peoples, which we call Indigenous peoples of Canada, are hereby recognized and affirmed. And so the reason that I put this up is because further to this, this inclusion of section 35 in the Constitution Act, there was a principle, an unwritten constitutional principle, which was carved out by the courts called the duty to consult and accommodate. And this, this principle was set to guide the way in which the Crown, which was deemed to be provincial and federal governments, related to Indigenous peoples. And so the duty to consult and accommodate applies when the Crown knows or ought to know that Aboriginal or treaty rights may exist and is considering actions that may affect these rights. And so the reason that this principle came about is because the federal government would just not consult with Indigenous peoples about their treaty rights or about their rights. And they had to go to court to basically argue that the government needed to come to the table and consult with them if they were planning to undertake activities that could affect their rights. And so the important part for us in thinking about the duty to consult is that this requirement only applies at the moment to provincial and federal governments because of the structure of our Constitution and because of the case law that we have. But it's a really important right. It's not, I actually argue in a paper that's coming out that it's not the right way to think about relationships, a nation-to-nation relationship at all. But one of the reviewers in this article said, that's very, utopian. You should think about what the duty to consult has provided. And that's an important reflection to make. The duty to consult brings the government to the table. It forces the government to come and acknowledge that there are rights that apply that need to be engaged with. And the way that this right has evolved over time through the courts is that there's basically two kinds of rights that are associated with it. There's a procedural right, so having a process that's fair, and there's a substantive right, so that the actual Indigenous concerns relating to the action are addressed. And what the courts have said is that the content of the duty, the extent to which the duty to consult is actually is procedurally drawn out, has to do with how strong the Aboriginal right is itself. But what the courts have said as well is that in a very small number of cases that have actually gone to the court, is that this principle, this duty to consult and accommodate, does not apply at the municipal scale. And the reason for this is twofold. One is that the honor of the Crown the basis upon which this duty to consult and accommodate exists is non-delegable. It can't be given to any other party. Not the procedural part. The procedural part can be given to, you know, an administrative body or municipality or what have you, but the actual legal responsibility cannot be delegated to any other party. It rests with the Crown. And the other reason that the courts have set out is that municipalities do not have the resources or mandate to have an obligation imposed on them to consult. Now, for the non-lawyers in the room who are already thinking up lawyer jokes, the point is about this case is it had to do with a very small municipality, Salmon Arm in BC. And of course, we know for larger cities that they may be the size or even larger than provincial governments. They may have lots of capacity, lots of funding to undertake the duty. And so, you know, each legal case is really a story in and of itself. And this story happened to do with a very small municipality. So we don't have really good case law that's fleshed out how this duty would apply to larger municipalities. Now, many academic commentators have said that the duty to consult will likely evolve to include municipalities, at least from a practical perspective. Angela Delia Decembrini and Shin Imai wrote a very compelling paper a couple of years ago that said, listen, we know that municipalities are already engaging in consultation and accommodation with Indigenous communities. So it's already happening. You know, whether or not the courts say it is, who cares? I mean, not really who cares, but you know, that's not the important bit. The point is it's already happening. And I'm just gonna, if I have time, if Gima doesn't tell me to be quiet, I'll tell you a little bit about that as well in my conclusion. And then other scholars have said, listen, if you combine this case law with emerging case law, really the obligations of municipalities are already, you know, if this case came again, especially in a larger urban center, you would see that the duty to consult and accommodate already existed. But what I want to conclude with is a third argument that I think is one that I hope that we have a chance to talk about as well, which is that many First Nations are already pushing for different kinds of Indigenous municipal relationships beyond the duty to consult. You know, having some kind of obligation for consultation as a baseline, but pushing for relationship building and more, reciprocal, respectful relationships in other forms of relationships. So in Joanne's presentation, she spoke about how some municipal governments are already modifying their governance practices. And there are some municipalities, there's many municipalities that have Indigenous affairs staff, that have cultural competency training, that may have advisory committees. There's place naming that's happening in many municipalities. So there are, over the last decade, we see some emerging efforts to acknowledge that governance itself needs to change in order to make sense of the people who are actually living on the lands within which the municipality exists. Beyond that, we also see a number of important agreements that exist between First Nations and municipalities. So this is a chart from the Union of BC Municipalities, which shows in a really user-friendly way the breadth of agreements that exist amongst First Nations and municipalities. And some of them require and mandate municipalities to engage in more formal consultation efforts, sitting in ceremony, and really work to improve relationships. This is very well documented as well in a book by Chris Alcantara and Jen Nellis, which I'd recommend if you're interested in this topic. So this is one place where we see changes at the municipal scale. And one of the more promising efforts that we're seeing of late is the adoption of Undrip as the basis for relationship building. So the federal and provincial governments within Canada have been very slow to adopt Undrip. BC has and is in the process of looking at its laws and how they relate, how they respect the principles that are espoused in Undrip. But I would argue that municipalities have much longer been looking at Undrip, or some municipalities have been longer looking at Undrip as the basis for relationship building. And so it's a signal that there actually is the potential at the municipal scale for a richer dialogue and a richer way of engaging that can provide for that kind of baseline legal requirement of engagement, but better than that, moving towards a real acknowledgement of the lands upon which cities reside. So I'm just going to conclude with maybe some questions for our panelists. They can answer them because I don't really know the answers to these questions, but I think they need to be asked. What's next? What do we need to be thinking about? I mean, if cities are empowered by a constitutional change, that's, in my view, not just my view, but the view of, brilliant Indigenous scholars and lawyers who have long said, municipal power can't really be acknowledged without addressing Section 35, without addressing First Nations and Indigenous rights. And I think that's right. Any change to the federal constitution has to acknowledge the rights of Indigenous peoples. But barring that, the real challenge is that the policies that are introduced at the municipal scale are not uniform. There's not a solid foundation for what is actually required. That's where something like the duty to consult and accommodate is attractive, because it's a baseline requirement. So what is the baseline requirement for municipalities? It can come from the provincial scale, where there's a requirement under planning acts or municipal acts to engage or build relationships. But we really need some teeth, and that teeth needs to include funding and capacity for especially smaller municipalities to engage in relationship building. So I guess as a finishing close before Guima throws me out of the room, municipalities must have clear obligations to Indigenous peoples and First Nations. And the question is what? And the question is how?
So I guess I'm on.
Oh yeah, sorry. Please go ahead, sir.
Okay. Thank you, Alexandra. Bonjour, miigwech. First, my thanks go to the organizers for having invited me to this event. Any opportunity, as I said earlier to the other speakers, to see a face other than mine in the mirror is a great source of joy. And having only 10 minutes, I'll jump in immediately. I found the two papers very interesting because either directly or indirectly, they bring forth two critical issues. First, the common denominators, as well as the differences between the constitutional quest of municipalities and Indigenous communities. And second, how the Constitution structures the Indigenous self-determination debate in Canada and in the urban context particularly. First, what struck me in reading the papers are the similarities between the constitutional quest of both cities and Indigenous communities. All seek to be considered as constitutional actors within the Canadian Federation. All claim a right to exercise a non-delegated form of power. All suffer from jurisdictional fragmentation between the federal and provincial governments. And thus, to paraphrase the proposal overview of the Charter City Toronto initiative quoted by Alexandra in her paper, they seek, quote, a more equitable relationship with clearly separated authority, exclusive jurisdiction for the city or Indigenous communities, and clear rules on shared jurisdiction, unquote. They also emphasize the particular nature of the communities they represent. Indigenous communities are not mere cultural aggregations, and municipalities are not just creatures of the provinces. Instead, they claim to be public bodies that serve a democratic function, to quote Alexandra. In other words, they assert that their constituents are not mere individuals, but instead that they share a common citizenship as members of distinct political communities. The issue then is whether a constitutional space exists to recognize self-government powers to municipalities and Indigenous communities. If the answer is yes, the question becomes which cities and Indigenous communities are entitled to exercise such powers, and then what powers exactly are involved. Before addressing my second point, and it didn't rise up in their presentation, but I just wanted to say to Alexandra that I disagree with the proposition that I think you do agree with that, and I disagree with it, that municipalities could obtain such a limited sovereign exclusive authority by way of Section 43 of the Constitution Act 1982. Undoubtedly, creating a third order of government impacts the division of powers and most certainly the lieutenant governor's office. But that's a boring discussion between constitutionalists. The big difference between municipalities and Indigenous communities is that the Constitution authorizes the latter to negotiate with the Crown on a nation-to-nation basis. As potential holders of Aboriginal rights and titles, Indigenous communities are constitutionally endowed with a right to be consulted by the Crown and their rights accommodated. Thus, many authors inquire whether the Crown's duty to consult and accommodate should be delegated to mere municipalities. Most claim that this would undermine the nation-to-nation relationship. I do not want to quarrel with the fact that this is an important question. However, I just want to underline how the constitutional question structures how Indigenous self-government issues are addressed and how it impacts the internal dynamics of urban Indigenous self-government initiatives. Amartya Sen, in his book, The Idea of Justice, distinguishes between transcendentalists and comparativist approaches to justice. According to him, what he dubs transcendental institutionalism has two distinct features. First, it concentrates its attention on what it identifies as perfect justice, rather than on relative comparisons of justice and injustice. Second, in searching for perfection, transcendental institutionalism concentrates primarily on getting the institution right, and it is not directly focused on the actual societies that would ultimately emerge. The comparativist approach, on the other hand, focuses on the actual behavior of people and involves comparisons of societies that already exist or feasibly could emerge, rather than confining its analyses to transcendental searches for a perfectly just society. The concern for the comparativists is primarily with the removal of injustice from society. The transcendental inquiry addresses a fundamentally different question, quote, a question that may well be of considerable intellectual interest, but which is of no direct relevance to the problem of choice that is to be faced, unquote. I find that looking at the problem of Indigenous self-determination from the purely constitutional lens smacks a little of transcendental institutionalism with its emphasis on getting the institutions right. I recognize that finding a constitutional basis for the nation-to-nation relationship is vital, in that it would secure a self-government status against legislative encroachments. However, following the constitutional path has structural consequences. Demonstrating the existence of a right to be consulted is difficult and expensive. The duty will only be triggered where Aboriginal rights, mainly of a territorial nature, can be demonstrated. Finally, it will mobilize formal institutions, both at the municipal and Indigenous levels, First Nations Council, for instance, generally male-dominated formal institutions of that. Focusing on the constitutional doctrine also entails a fragmentation of the urban Indigenous front. Urban members of First Nations, Métis, and Inuit communities seeking a specific right to be consulted. The essentialist approach of the Supreme Court of Canada nourishes a divide and conquer dynamic between Indigenous communities themselves. In addition, the emphasis on state-centric constitutional doctrine as a means of dealing with urban Indigenous self-government issues might invisibilize essential characteristics of the urban context. What follows is greatly influenced by Val-d'Or's, a small city in the north of Quebec, Val-d'Or's Friendship Center's work whose Anishinaabe director, Edith Cloutier, is a researcher with whom I've been collaborating for years. Joanne's paper touches upon issues concerning friendship centers and other urban Indigenous institutions. First, the Indigenous urban reality is very complex, as both papers demonstrate. Small cities are as important as great metropolises. Val-d'Or, for instance, although statistically comprised of only a few hundred Indigenous citizens, is actually a very important transit center for many Indigenous peoples. For example, Val-d'Or's Friendship Center caters to all the Cree and Inuit people that come south for health services. Second, many issues daily faced by the urban Indigenous populations are not primarily territorial ones, and are for the most part common to all Indigenous citizens. Third, in urban areas, the Indigenous actors at the forefront of what Amartya Sen calls the removal of injustice from society are often actresses and not actors. These women have to deal with complex issues while fighting to get money in a context where the constitutional doctrine reinforces traditional institutions, chiefs, and other authorities, and their claims for more significant financing. Just recently, Radio-Canada reported how, in the wake of Joyce Echaquin's death in Quebec, the Lanaudière Friendship Center was ordered by leaders of the Manawan First Nation not to speak to the media. In 2015, when the Quebec government promised $6 million to Val-d'Or's Friendship Center to help finance social housing, the Assembly of Chiefs was infuriated, claiming the money should have been given to them. Members of friendship centers in Quebec, at least, have denounced multiple instances of outright intimidation. Lastly, and more importantly, this constitution-centric perspective invisibilizes how new Indigenous institutions, like the friendship centers, develop urban Indigenous legal traditions by creating new norms, adopted and implemented according to new processes, and led by new institutional actors. In other words, too strong an emphasis on the constitutional path might overshadow urban Indigenous legal orders in the making. Indigenous legal systems seeking greater recognition, and that, to quote John Burroughs, help emphasize constitutional law as a verb, to constitute, rather than as an abstract conceptual category. Thank you very much.
Thank you. Kia.
Thanks a lot, Chief. So I have 2 points that came to my mind during the talks that I want to bring up that I hadn't sort of expected to, but I think they're relevant to some of the themes that people have brought up. And then I've got a few questions that I'm sure will blend into the questions that people in the chat will certainly have. Professor Heritz mentioned the sort of the 9124 provision regarding Indians and lands reserved for the Indians. And I wanted to bring up a point that I'm trying to repeat, or at least bring up in as many circles as I can, because I think it's a powerful one and it's worth considering. That the first time I read of it was a paper by Joshua Nichols out at U of A. I think others have been sort of echoing it as well. I'm not actually sure where it started, but the idea is that Section 91 overall, when you read the section, doesn't actually say power over at the sort of preamble section at Section 91. It actually says power in relation to. And so if you read that in conjunction with lands, Indians and lands reserved for the Indians, the idea is that this could more properly be read and interpreted in the context of 9124 as along the lines of what was described in the Royal Proclamation 1763, which declared the proper level of relationship with Indigenous nations to be direct to the Crown, not with sub-state actors or individuals with whom there would be inherent conflicts of interest in terms of resources or settlement. The proposition is that 9124, fairly read and understood, should always have been construed, not as a unilaterally asserted power over hundreds of nations and hundreds of thousands of people, which interestingly is between like the powers over the mail and powers over marriage and divorce. It seems like an odd thing to just throw in there if that's really what it was intended to be. But as a constitutionalization of the promise inherent in the Royal Proclamation that the federal Crown will retain the right to exclusively treat and negotiate with Indigenous nations on a nation-to-nation basis, as they had done up until that point. The idea that you're constituting a power in relation to Indians and lands reserved for the Indians should never have been construed as power over people, in like a authority kind of context. So I'll just put that out there because I think that sort of changes the tone of a few readings and a few of the ways that if we're going to have these discussions around rooted still in the idea of 9124, reading it and keeping our minds open to all, alternative ways that it might have been understood or misconstrued, I think could be really important. The other thing that came to mind was, and this is sort of more along my own wheelhouse, that I've been investigating the honor of the crown in my recent work. And, as the origin of the duty to consult and accommodate, not necessarily devolving to municipalities, brought up this interesting point, because in the way that I've been doing some research around it, the origins of the honor of the crown actually went back to the 11th century, in like the origin being in kind of limiting the power of agents of the monarchy. So in the sort of principle rex non potest peccare, that the king can do no wrong, went through all these iterations in like, first that they literally couldn't do anything wrong because they were the king, but then that they were constrained by constitutionalism. But then the interesting thing pointed out by a fellow named Guy Seidemann was that when I think it was Henry III came to power, it was in minority when he was a child, and so literally couldn't do anything. And so whenever agents of the crown acted on the king's behalf, they had to figure out, well, the true power of the crown should lie in the hands of the king, but it's being exercised exclusively by agents of the crown, which is, of course, the government situation that we now find ourselves in. And so the honor of the crown was seen as this interpretive principle by which the actions of those agents could be held accountable, and that the agency of the crown could be stripped of them post hoc. So if they did some treaty or engaged in some negotiation that didn't actually fulfill the honor of the crown, basically anything the king didn't want to put his name on, then it could be rolled back. It was like a rogue agent move, and they could be punished accordingly. And that got sort of moved through history into now being this. If I think it's right to say that a lot of the constitutional principles in Section 35 is rooted in this honor of the crown principle, but to say that it should be limited or read down to this idea that it merely produces the duty to consult and accommodate ignores hundreds of years of this history and really being meta-constitutional. Like I think it's arguably a charter value insofar as the principle of what agents of the crown, which is now literally every actor in government, has to do in order to meet the standard of being a good sovereign agent and not acting for the public harm but for the public good, means meeting the honor of the crown, holding promises. If you're the source of all sort of justice and legality in the country, you yourself as an agent of government cannot, make and then break those promises. The idea of parliamentary supremacy is heavily undermined by this idea of the honor of the crown being something that has in equity a strong sort of moral bent to it, which is the way it had sort of. Now you can argue that changed after the Constitution Acts and that it was sort of in a more modern parliamentary supremacy era. But if we're going to be talking about the honor of the crown, I think it's important to understand its roots in that equity, and that when those original treaties were being negotiated, it was in that context because it was pre-constitutional by definition. And so if we're going to correctly read the honor of the crown into what the obligations were on the agents of the crown negotiating those treaties, the people, what was going on in the minds of the agents essentially doing the contracting, understanding what the honor of the crown should have meant at the time and the obligations upon them when they were doing that, and how they were sort of obligated all the way up to keep promises and that kind of thing. I think there's a much more interesting dialogue to have there, but that would also inherently mean that municipalities as agents of the crown on this reading would automatically have that authority not delegated to them, but obviously they would be beholden to it as the power is flowing down through that pathway. So just something that popped out there. So the questions that I had that I thought would be interesting to start off with were the idea of FPIC and Undrip came up in Professor Flynn's paper and discussion. And I think she said, if I'm not misquoting, that FPIC would likely result in a veto power. And this is at the Toronto adoption level, not at sort of a provincial or federal level. So I'm not sure if that makes a difference. I'm curious to hear if it does. But it would likely result in a veto power. This has been a hot button issue for a while, that Indigenous groups would have the power to sort of intervene on policy at whatever level Undrip is being adopted. And this has been largely, as far as I'm aware, defended by saying, but the overarching scope of Undrip is such that it will never derogate from state power, or will never, there's this overarching theme within how it's drafted that says, but. So that when you're reading FPIC, it's in this overarching umbrella context of, but not in any way that could ever construe so as to, derogate from state power, parliamentary supremacy, influence, etc. I'm curious if you think is that how it's going to play out at the municipal level if these kinds of things are being adopted? Like if you have cities signing on essentially to kind of an Undrip mandate, and they do start to take on some of these additional authorities, it seems to be interesting because they're not actually bound at the federal or provincial level by that same kind of constraint, and yet they're adopting Undrip. So do you think that FPIC would have additional powers at a municipal level where it might not actually have those things at a provincial or federal level? And this is, of course, open to everyone, but it was inspired by Professor Flynn's paper.
So who wants to have a comment on that?
I mean, I'm happy to
Alexandra?
answer. Yeah, sure. You know, I'm sort of relentlessly optimistic about most things, but maybe not so much this. I think that Undrip has as much, unfortunately, has as much power as governments are giving it. And I don't know. I mean, I don't know if we've seen the results of Undrip in actual decisions that municipalities have made. We've seen them endorse it. We've seen commitments and, you know, coming back to the mayor with policy recommendations. And so I don't know. I mean, I think there has been change at the municipal scale, but amounting to FPIC,
Right.
yeah, I don't know. I mean, I think so. Part of our larger conversation is that so much depends on the place. And that's where it's really challenging to have one way of crafting rules because every place is different. And the categories that we attach to things don't fit very cleanly. I mean, I totally agree that that smaller municipalities are actually a really interesting place to look at how relationships look. Because the consequences are so different, or can be so different. So I think I don't know, I'm sort of like hemming and hawing, but I think the short answer to your question is it really depends. What are political leaders willing to do? What are they willing to stand up for? I'm really intrigued by the way that the city of Toronto passed Undrip, which was in a much less direct way. It just kind of happened, you know, and I think there's a lot of interesting potential for that. And, you know, I've been involved in a really interesting community-based project, which has seen the impact of having an Indigenous Affairs office and sitting in ceremony. And I think Undrip is part of that, but it's not something you would see in newspapers. It's a very, you know, kind of behind the scenes relationship that's coming to be, that's all about governance. So I think it matters, but FPIC it's complicated what that means. It's complicated and super simple, right? Like it is,
Right.
But it's so much depends on the time and the place.
So can I make a comment on Undrip in a broader sense? Simply it relates to legislation that's being worked on right now with AFN and the federal government. You know, as the Mississaugas is a credit First Nation, I'm not associated with a PTO, a provincial territory organization, nor any other type of tribal council. I'm barely associated with the Chiefs of Ontario in that we go there to observe, to make sure that they're not stamping on the rights of the Mississaugas to credit. Our relationship with the AFN is, you know, is superficial. We don't necessarily agree on a lot of the positions taken by the AFN because the AFN is a political body that's supposed to represent so diverse First Nations across Canada that it becomes an impossible task. So to me, the institutions that have grown to purport and defend the rights of First Nations, Indigenous peoples, need to be replaced and revamped. And I'll say that outright to anybody who asks. Even though the national chief is a friend of mine and the regional chief to some degree as well. The issue with Undrip, as it's seen by some chiefs, is that it's being watered down too much and that it's going to be looked at as, you know, the derogation clause in section 2.2 are going to be looked at as, in some people's eyes, relying solely on section 35 standards. And we have inherent rights that justifies our existence and our ability to form our own governance and do our own work and create our livelihood. So that's a big concern. The issue of the doctrine of discovery not being rebuked or taken out or condemned as a source of discovery of this land is another issue. So there's a number of issues where now we have some First Nations calling for this to be put into place. Another First Nation saying this is absolutely wrong and it should not be taken into the Canadian system in this format unless it is taken in the exact way that it was intended at the United Nations Declaration. So those are problematic issues in First Nation country, and I'm sure that's going to, however that happens, it's going to flow down to municipalities and their relationships with First Nations. So, any other comments on the Undrip issues or anything else?
Well, there are interesting messages in the chat. I don't know if are the people able to intervene, because Mariana Valverde has something to say, and I thought it would be interesting to hear what she has to say, even though we can all read it.
So we were actually looking to, hear if there are any more discussion points for anybody on the panel, and if not, we're going to take some questions from the chat room directly.
I think we wanted to reserve 20 minutes for the chat room, so I'll give up the floor to that. See what people have to say. Okay, so then we have 20 minutes, and I apologize to everybody. Can we, if you have a question, would you mind? Because there's been a few of them throughout this conversation. Would you mind if we sort of restate it to your question and who you direct it to? That would be beneficial. And while you're doing that, I will actually go to the last one that's on my screen right now, which is from Sancho McCann, to all panelists. For the Crown to be able to rely on a broad tribunal to fulfill duty to consult, the SCC has said the board tribunal needs to have the powers to enable it to do what the duty requires in the particular circumstances. It seems cities are often quite constrained in the kind of bylaws they can make without provincial approval. Example, Victoria's plastic bag ban. Do you think municipalities, even large ones, have enough delegated power to accommodate such as they can fulfill the duty?
I'm happy to take this question. This is, I think, is it fair to say, Jean, that this is like an administrative law question? I think so. I mean, well, the plastic bag ban case was a constitutional law case, but I think what this is getting at is that under the Constitution, municipalities are like any other administrative body. So like the local water board or, the DMV giving out license plates, like under the law, the courts have a right to review the decisions that the municipality makes to determine whether they're reasonable. And so what Sancho is asking, I think, is there enough power that municipalities have to be seen as also having the responsibility as a crown for the duty to consult? And I think that, there was a case that went to the Supreme Court that looked at an administrative body that had been delegated a lot of power, like tons and tons of power, including the procedural duty to consult that I spoke about earlier. And such that the court said they've been delegated so much power that they really are responsible for consulting. And so some scholars have said in the municipal context, it would be the same, that because cities have been granted so much power, especially in regard to planning, they would be seen as having the duty. And I guess I would say, at the end of the day, I really do agree with Angela and Shin, who said that, it doesn't, like, at the end of the day, somebody's responsible for the duty to consult. And so the province is going to step in if the municipality doesn't do it. But I think for the First Nation and Indigenous peoples, it's such a pain to have to go to these, like as John Burroughs has talked about at length, all of these different jurisdictions to try to figure out who's going to be the one who's going to, levy the hammer. I don't know. I think there are it's so much about the case and the case that would come to the courts, but I can imagine some cases where the courts would say that the municipality has been delegated full authority to pave roads or, manage a park or whatever, that they essentially have the duty because it's been delegated to such a great extent. There's this tiny piece that's retained by the Crown, but most of it has been delegated. But but then you'd have to go to court to prove that, basically. I don't know. Does anyone else have any thoughts on this point?
I just really have, I know that you're really getting to the legalities of it. I'm just actually, I just wish to contribute something more anecdotal if that's okay. Just, and there might be some people out there from Edmonton, but I just know of, just from the research that I've done there, that any, the lands along the, I believe it's the Saskatchewan River, anything that takes place along within the municipality, even if it impacts on, let's say, one area where First Nations might be First Nations territory, that they consult all the all the First Nations, because they don't know sometimes where one where one jurisdiction would end and another one would begin. So that's, I think that's the idea. It goes back to what you were saying about sometimes it really impacts upon some of these groups because they're, because of the time that's involved. But it also too, it's, I think it's the idea of trying to build inclusivity with the municipality and First Nations.
Okay, there's another question here by, and forgive me for the names, I'm very horrible at that. Pershautama Reddy, it asks, would self-governance be sustainable in the case of smaller Indigenous communities? What will the final governance system and structures look like on completion of the process? Who wants to take that one?
I can give it a shot.
Okay.
Well, it starts by the first step. Do you want a one-fits-all solution to every Indigenous community in Canada, whatever its demographic, its geographic position? I think then we have a big problem. I think that some First Nations will be able, or some Indigenous communities will be able to exert the political pressure to sign treaties, others will not be. And this brings into question, what John Burroughs addresses in one of his books is maybe in some cases a federal legislation recognizing inherent jurisdiction over local matters would fit for one community. Another one is able to negotiate treaties. So I think it's all going to depend on the situation of these very diverse Indigenous communities.
Kia wants to take a shot.
I would also just add to it, yeah, this was actually going to be a question that I was going to bring up because it's relevant to, but like the way that we're talking about municipalities seems to overlap with also the way that a lot of final agreements, like a lot of the communities we're working with now on Vancouver Island, and some that have final agreements do actually seem to have these kinds of structures that are being objected to. Like the mayor, I think it was of Gatineau, talked about how they're 8% of the budget, but like they provide 51% of the infrastructure costs or something, and how so many of the tools around property tax are insufficient because they're sort of go back to feudal times and they don't seem to actually give the tools to the communities they need. A lot of the final agreement text is actually importing a lot of these tools into how these communities are supposed to be then running their own self-governments. And so like, to what extent can we learn from the mistakes of municipalities in changing how those agreements are being structured? Because they're being essentially given the same tools. And if they're not sufficient for cities now, why would they be sufficient for communities that are sometimes a few hundred people with incomes that are less than half of the Canadian average, and they're supposed to generate property tax in a vacuum without provincial support in 10 years? Like, it just seems like they're not thinking this all the way through, especially when they're essentially making like mini municipalities they have some quasi-provincial and quasi-municipal powers, but depending on the agreement. But like, it seems like they're not looking carefully at the kinds of tools they're just passing right along. So that's just a comment that I'm encountering. It would be interesting if people had sort of policies or things that are working in municipalities that could also improve conditions in these kinds of agreements or change the way that they're construed to be more feasible at that level. I'd be curious to hear, but I'm not expecting anything.
That's a very interesting comment, Kia. I've heard my council and other councils many, many times say, we are not a municipality and we refuse to be treated like one. Well, I say to them, well, stop acting like one. because a lot of First Nations, they'll say that, but they really do sort of deliver the same type of thing. And depending on the agreements that are, and the authority, quotation marks, that is passed down to them by the federal government, they take on a role municipality. So I have nothing against municipalities, and I think that the greatest friendship could begin there with your First Nations and the surrounding communities. I also think that with cities, the opportunity to look at First Nations as partners in building a strong economy is so vast that we should take advantage of it immediately. You know, I have plans of my own in regards to that type of thing, and it doesn't just involve my First Nation. It's very broadly. And when it comes to the question of small First Nations and can they actually function as self-government? Well, the confusing part was Justin Trudeau's announcement that, you know, the most important relationship for me is First Nations relationship. The next thing was, I want a nation-to-nation relationship with you, with the First Nations. Well, there's no definition in his mind to that I could see. And so First Nations are left with, well, what does that mean? How do we do this? And so, and personally, if you're talking to a nation-to-nation relationship in this country, you're talking about a separate system of law and justice. You're talking about a separate army. You're talking about separate policing. You're talking about a separate system outside of the Canadian system. And if that's what he totally intended, it can be done, but it requires vast support from the Indigenous people across the lands. It doesn't depend on one community or even one First Nation or a group of First Nations. So for ourselves in my community, we are structuring from the ground up. I'll say it like this. I was talking to a chief the other day who I really respect, and she was saying, I need to examine all the legislation, all the policies that impact our people so I can figure out how to get out of this mess. And I said, Chief, you're going to spend the rest of your life doing that. And when you get done, you'll be 2 feet from where you stand today. I said, I'd rather spend the rest of my life building something from the ground ups that I had the inherent right to do and make that my life's work. But I recognize that Mississaugas is a creditor of 2,800 people. As a Mississauga nation called Michissagi, we're 10,000 people. So we realize that we can go a long way in our own justice systems, in our own policing systems, in all our own way of lives. But we can only go so far until we have the support of the Mississauga Nation, of the Anishinaabe people, of the Indigenous people of the land. So to build a structure that can do what Prime Minister said, we need the people of this land to collaborate, and keeping in mind that we're always looking at how that growth of our First Nation is going to impact surrounding systems and how do we incorporate and make sure they're respected, you know, until we get to a point where we can provide our own leadership and legislation where our own systems take over. So it's an interesting question about can First Nations survive in their own self-governments, and I say not in the concept of what people envision it to be. I think John was right when he talked about that you know, certain systems and certain models works for certain people. And if you're just focusing on your own self-government models, you know, they're so diverse that you can't measure. One form of legislation won't do that. You have to have something that's broader and allows to differentiate the complexities of First Nations in Ontario and an evolution of First Nations in Ontario, because that is so different than the rest of Canada as well. Sorry, there I go hogging, Mike. I apologize.
Thank you very much. No, it's great.
So
It's also, can I just add, it's also going to take a lot of time, right? I mean, you know, like it's so unfair to expect First Nations to be, not that, you know, anyone was saying this, but it's so unfair to expect First Nations to be, you know, have fully formed institutions and codified laws or what have you at this stage. I mean, it's, there needs to, even just figuring out what are the laws and how to express them and, you know, how they apply to this specific nation and what relationships are like with other nations. And, you know, I mean, the process of colonization is a colonization of First Nations institutions too. And so how to unravel that is going to take time. And I think there needs to be space for that to happen without imposing, you know, clear.
That's very interesting. It reminded me of something else. And this will be my last comment. No, I'm lying. Let me think. I lost my train of thought. With regards to how I was going to answer that regards to this question. So I'll just switch over to another question, so I won't take up too much time trying to reclaim it in my memory. Okay, here's a question from Natalie. I think I know her. Consultation can be a powerful tool of democratization and inclusion. It can lead to better decisions. We want public input on budgeting and on planning because it leads to better decisions. That is more legitimate. I don't know if there's a question out there or just a comment. Would anybody want to make a comment on that? I had to get her in there. She's a boss. Okay, here's a question.
I have an answer. I mean, if
Okay.
people are sick of hearing my voice too. Gima, Laforme, if you remember what you were going to say, just jump in so that yeah, because I think we all want to hear what it was. But yeah, no, I think where consultation gets conflated is what is consultation for the public and what is consultation for Indigenous peoples? Like, is it the same consultation mechanism? And not to belabor the duty to consult and accommodate or suggest that it's the perfect model, but it does provide that it's, it's specific to the nation. It's not just a general like open house where you come and, figure out where you want the park benches to be. It's specific to the Indigenous peoples that are affected by the decision. It's translated into languages that are appropriate, and it's, in a model or form that's appropriate. And I think, where things can get problematic is many municipalities have very robust consultation methods, but they're not designed for Indigenous residents or for First Nations that are within or surrounding the municipality. And so I actually think like taking, there's a lot of critique of consultation itself, like not Indigenous consultation, but I mean like consultation generally, like top down, and you're not really listening. And I actually think with consultation, we could take a page from many Indigenous communities that do consultation way better about like listening and paying attention and, hearing from everybody, hearing from anyone who's affected, not just like the neighborhood association, so I think I agree with Nathalie. She's right. It is really important, but what are we just doing it because we have to, or are we doing it because we really want to make better decisions?
That's a good point. We're running out of time. We only have a few minutes left. Was there anything else from the panelists before we wrap up? I really want to thank everybody for being in attendance, and I thank Massey for doing this, and everybody on the panel for imparting your wisdom. It was fun. I wish we had another couple hours just for questions and answers, because much as I enjoyed your presentations, I would rather have the dialogue and interaction with the audience as opposed to the amazing presentations that were presented. But so if I'm going to just tell you that I remembered I was going to talk about we have a table at the self-government's tables that Canada put together, the rights tables, and people around here called them the self-government elimination tables, elimination of your rights tables. And so I said, I understand with your perspective. I said, look at it like this. For me and my First Nation, we're walking along away from the Indian Act and those systems to our own destination. I said, along comes Canada. They say in a bus and says, do you want to ride? And we say, okay, if we can drive. So we get in, we go down the road as fast as we can, keeping in mind we're using all the tools they have to make sure we have all systems in place for our First Nation to do what we need to do in our ways. But if that bus ever goes in a direction that we do not want it to go, which it will eventually, we pull over to the side, we get off, and we start walking again. So I say, don't be afraid of the systems and tools they have. Just be aware of what your intent is and your vision is, and don't lose sight of that, and you won't have to fear. So anyway, I thank everyone very much, and I'm sorry if I talk too much.
Thanks very much.
Thank you. Thank you very much. Thank you, everyone.
Lama P.